Hello everyone, welcome to yet another episode of the Africa Law Tech Show, a show that seeks to explore the different topics and news at the crossroads of law and tech. For this particular episode, we are going to continue our series, that is the data protection series, to just explore the different practices, the foundation and where it is we are coming from. And for this one, I am joined with a very special guest who's going to be giving us a foundational analysis of data protection in Kenya particularly, and where it is this conversation started. So welcome, and I will allow you to introduce yourself.
Hello everybody, my name is Joseph Kihanya. I'm a lawyer in Kenya. I've been for quite some time, and I've been in this space for a couple of years.
Thank you for joining us today, and I think we'd really like to appreciate the backdrop within which we are having the data protection conversation as we know it today. And so I would like for you to set for us that context. Where did this conversation on data protection begin in Kenya?
Very well, thank you, Rispa. I think it was maybe around 2007, 2008. We had an interesting model of business that was largely being done in India, and Kenya was also a target market. A lot of people may not know it. It's called business processing outsourcing, which in current terms is what I think the last administration was implementing as Ajira Digital. So that's the background of how that went about. So that then for you to be able to deal with call center activities, essentially in Kenya, most of the companies that would be giving out this information to you to be able to deal with needed to know that you have an environment that protects privacy of their citizens' data, because that's what you'd be dealing with. Otherwise, businesses would not release that information to you. So that's essentially was the background in which Kenya was then looking at getting into that space, and then the question of get into an environment where the data of these citizens is protected, therefore, so that our citizens can then engage in this business.
That's interesting.
And a few call centers were set up, if I remember.
Okay. And so then how was this conversation picked up to the point where we now came up with the 2019 situation where we enacted the Data Protection Act?
It seems like a long time, but it took a while, because that conversation was picking up, and 2007, 2008 is pre-Katiba 2010.
Yes.
So essentially, that was the question of the right to privacy was not there, other than what we know maybe at common law. That's a discussion for another day as it has developed. But by the time then the 2020 Constitution was passed, then there was an articulation of the proper right of privacy in the Constitution, so that then those conversations then took on a constitutional implementation matrix. That is where then that question arose. There was a tie-in between data protection and access to information, and access to information then had I think it had a 3-year implementation matrix under the Constitution of Kenya schedule. So there were lots of conversations around how the two would go together, although one had more preeminence over the other. Access to information had a larger preeminence, and what you'd want to call the right to privacy, which has been conflated now. Seems to have been reduced to data protection. But the right to privacy is a lot more broader than data protection. Although one would then suppose that any data breach is a violation of the right to privacy.
That is true. And so maybe take us through the process to what we have as the Act now. Take us through what that process looked like and some of the challenges you probably experienced.
Overall, what was in the public domain is that there were drafts, and there were lots of conversations coming from the non-state actor sector, what you'd want to call the NGO sector. Of course, there were maybe contributions by businesses in relation to the very early layman's drafts. What you don't call, they are not bills, they're just drafts out there that people are commenting on. There are some non-state actors who are more into it than others in relation to that question, and some of them held these conversations in seminars and workshops together with the access to information. legislation. So that's how that took that turn, and somehow over time the Access to Information Bill got to Parliament before the data protection one, and that was passed before the data protection one. And I think it's then at that point I had to be somewhere else, and I disengaged a bit from those processes, and I was quite happy to see the bill passed in 2019, what we have currently as the Data Protection Act. But the challenges, one would then say, is that some of these, it's not the right per se, but the manner in which it is understood, it's something difficult to express, so that we perhaps don't even have in local languages what that means. What a European perhaps understands as privacy in the environment is perhaps what we should understand. But our environments seem to have different challenges in relation to that. And that obviously then, for me, has led us to the situation where we are in, where we have an act, which is then policy, but a lot of people still tend to think this is a lawyer's field. It's not very regular that you walk on the street and a person tells you I have a right to privacy, let alone that I have a right to data protection. So that's a challenge, and you may have the data protection office, you may have, but as long as citizens don't get to understand, for instance, I have a right to a clean environment, it doesn't matter how much legislation you pass if they themselves don't understand that's a right. So that when they see somebody doing something to an environment that is detrimental to their right, then they are more the enforcers of that than perhaps a government agency or the entirety of the executive. That's perhaps where, in my view, that's where the challenge is. The challenge is not what the data protection office may do or what the judiciary may do when a suit comes up. It is the daily engagement by everybody, and citizens, I mean both real and incorporated citizens, how they deal with this right on an everyday basis.
And so maybe I could interject and probably ask, considering what you have just highlighted, are you noticing any change in function prior to the Data Protection Act and now?
You would have to maybe split that question into two. The function of whom?
It could be the citizens as we know them. It could be the corporations, people who are setting up within our jurisdiction. So you could tackle it either or.
Okay, very well. There's an awareness. There's an awareness about the creation of the Office of the Data Protection Commissioner. There's an awareness of the existence of the Act. There's an awareness by some people, appreciable appreciation about the right to privacy, because the right to privacy, it's something that is with every human being.
Yes.
It's something with every human being, even sometimes perhaps even if you don't know it. There are people who will feel when their right is being violated, quite irrespective from the fact that they do not know that there's a Universal Declaration on Human Rights on a certain question. So it's per se, I would say, that doesn't seem to have translated. I would, for instance, want to know, or rather maybe somebody can do some research, find out how many corporations have changed their practices as a result of the passage of the Data Protection Act. Go to a corporation, ask them, have you changed any form? You collect personal data of data subjects. Have you changed the way in which the form that existed? Is there a form that existed prior to 2019? Do you have a new one for maybe 2020? And you'll find that largely, I would hypothesize, nothing has changed. Whether it's in the public or in the private sector, because some of these things take time, especially in our, what you'd want to call our practice, where forms in relation to certain access to services by government or by corporations, mostly by government, are in schedules to legislation. So that subsidiary legislation has forms. So you can't change the forms unless you change the subsidiary legislation. So that you'll find a lot of those hasn't changed. Although maybe one may then posit to say, and maybe I'll digress in relation to this and point out that what is really causing a change in the manner in which data protection is considered in our environment is cybercrime. Most people don't think about it that way. But as long as data is being collected in massive quantities, there is sometimes an incentive for somebody to gain access to it and get it to somebody who needs it. Now, there are processes where the Act says this is how you should transfer personal data, whether within the jurisdiction or outside the jurisdiction. But then in the case of cybercrime, cybersecurity breaches are by people with higher incentives than what one would normally consider to be, so that they then impact the question of data protection to a level where we are looking more at heightened cybersecurity awareness as opposed to just the mere compliance with data protection. You will find in many data breaches, it's a cybersecurity breach.
So then how would you advise that we proceed when it comes to just the practice of, data protection and also being involved or integrated within this particular industry?
They said something a while back. This is not me saying it, but there's been some push out there where they talk about chief information officers, that the chief information officer is actually the CEO. So that when you think about information and when you think about cybersecurity, when you think about data protection, it's in the CEO's office. It's not the IT person, quote unquote, on ground floor. If it's not in the C-suite, there is a problem. Yeah, that's all I would say.
That's interesting.
Yeah.
So having that overall or general layover, then that is what is trickling down to everyone else within the organization.
Absolutely. What I'm saying is that if the CEO is not aware of what's happening with information in the organization, there is a problem. In terms of how secure are we? And security is not it's not something we did last year. Security is what you did 20 minutes ago, maybe, or even less. You are only as secure as you were a minute ago. Maybe, or less than a minute ago. So it's a continuous process. It's not something you say, no, we implemented this 3 years ago, we are good. You're not good. You're not as good. You're not good because the persons out there who are gaining more knowledge than you in relation to what you have deployed have all the time in the world, and they have capacity to deploy it sometimes for fun. Yeah, some people just do this for fun. They can breach whatever office they want to breach just to show that we did it. We did it,
yeah. That's true.
Or it can be done, so to speak. Yeah, so.
That's interesting, and I like that the call is to not just, particular functions within the organization, but it has to be a more holistic kind of mindset towards, these issues. So I think with that, I'd ask for any final remarks that you may have on this particular topic.
Yes, I think it's an interesting area, and I think if there's judicial notice one can take off, I think maybe the first class action lawsuit in this environment. In other environments, that is par for the course, in the sense that the class action lawsuits are there every time because the data breaches are massive, and the lawyers in those environments are prepared, and they have been in that public interest, what we call public liability space, for a long time. In my estimation, if data and information is as lucrative as it is in the days and years to come, maybe we'll not be talking of ambulance chasers for advocates. Maybe we'll be talking about class action lawyers for data breaches, because that's for lawyers who may be watching this, that's perhaps the space to go. It's not so much that you need to be a data protection expert. You just need to be a very good class action lawsuit lawyer and public liability, what you want to call public liability action lawyers. So that's the way I feel, and I feel also that maybe with time we will see what happens to the determinations of the Data Protection Commissioner, because they will make determinations, And under the Act, an appeal lies to the High Court.
Yeah.
So that means their jurisdiction is not perhaps as strong as it should be.
Mm-hmm.
But when they appeal to the High Court, then we'll see what the High Court says in relation to the determinations that they make.
Yeah.
In other jurisdictions, for instance, the Data Protection Commissioner or those offices, or in a class action lawsuits, there is a figure that a citizen knows, or there's precedent that if this data breach occurred, every single one of who was affected by that data breach will get X amount of money. I don't want to put a figure in Kenya shillings, but it's something that is out there, and that's a practice out there. So it's something to watch out for. The culture is changing, the environment has changed, and it's going to continually change. So maybe it's for all of us to keep learning every day, like you and I are in relation to this conversation. Even I, researching for this, I came across something maybe I hadn't thought about maybe last week.
That's true.
Yeah.
And thank you for that, Kihanya. I think it's been very enlightening, and the broadness of it is that continual learning, being actively engaged within this space. And so it's a call to you to join us as we are trying to explore more within the privacy space, within the data protection space, and cybersecurity, I think, as he rightfully mentioned. So be alive to these issues as they're emerging, and see how you can be able to actively, engage and participate. Again, that's just a kind reminder to subscribe so that you don't miss any future episodes and discussions that we may have. And with that, I'll say goodbye. See you next time.